one based on their status, or a restaurant. And that distinction you've been talking about, what is the creative message behind this website that Lori Smith wants to be able to provide? And how will that be different? And a lot of discussion about, is a save the date message on a website the property of the couple getting married, or is it somehow a creative expression of the person doing it? And Justice Sotomayor writes that this is discrimination based on message, not status. So there are a lot of concerns about what this will mean for larger implications. And so often with a case like this, it's looking at very specific circumstances, the free speech argument, the artist involved, dealing with what is public accommodation under our laws. But the implications are so much broader and certainly will be perceived by many Americans who won't know the specifics of what was argued in this case and what really brought about this clear ruling from the court 6-3. We would expect that the White House would want to comment about this and to try to find other ways to be supportive of the LGBTQ community. And certainly when it comes to the issue of free expression, First Amendment rights are among the most sacred, and certainly we got that impression listening to the arguments in court, and at the same time trying to make certain that there is no discrimination against persons who are different in any way or are in a minority status. So this case will have long implications, Savannah.
Absolutely. Kelly, stand by there, because I should mention to our viewers we await another huge decision from the Supreme Court, which is meeting at this hour, releasing decisions on the final day of its term. That decision has to do with President Biden's plan to forgive student loan debt to millions of college students and former college students. So that hangs in the balance as well. But for the moment, we are discussing the case that came out just a few moments ago, where the court has ruled that a wedding website designer in Colorado who said she did not want to design wedding websites for same-sex couples as a matter of conscience because she does not disagree with it, the court has upheld her right not to do so, citing the First Amendment. Let's go to Danny Savalos, our NBC News legal analyst, who joins us as well. I'm reading from the opinion here, Danny. Justice Gorsuch saying the First Amendment's protections belong to all, not just to speakers whose motives the government finds worthy. In this case, Colorado seeks to force an individual to speak in ways that align with its views but defy her conscience about a matter of major significance.
The threshold issue here was always, is designing a website a sale of a product, or is it speech? And once the court determined that it was speech, the path was clear to conclude that speech cannot be compelled. And that's exactly the issue here. The web designer's argument from the outset was a distinction between, I am not discriminating against the people who come to me. I'm discriminating in the sense that I am not choosing to endorse their message. Their message conflicts with my religious beliefs. And as Laura Jarrett pointed out, it doesn't have to be religious beliefs. It's really about compelled speech. So the argument by the web designer was always that, look, this isn't discrimination against people. It's my choice not to speak about a message. And the liberal justices, Justice Ketanji Brown Jackson, Justice Sotomayor, pointed this out in oral argument, that this is a slippery slope. You can imagine how this can be a distinction without a difference, how very quickly someone can, for example, say, hey, I do these specialized photographs. And while I will serve, say, an interracial couple or a Muslim couple, as soon as they ask to be in the photograph, and I say, well, wait a minute, I don't do photographs of interracial couples or anything else that I don't want to do a photograph of, you can see how very quickly considering serving a particular customer can quickly become discrimination disguised as an argument against compelled speech.
Well, that is the big question, and one of the, as you note in the oral arguments, was debated by the justices at length. How far does a line like this go? What kinds of goods and services can be denied by citing a First Amendment right in a person's matter of personal conscience? I want to turn to Jennifer Mascott. She clerked for both Justice Thomas and Justice Kavanaugh. Joins us now. She's an assistant law professor at George Mason University. How do you view this decision so far?
Well, interestingly, again, today we have 6 justices in the majority, like we did yesterday in the Harvard and UNC cases. And so a clear majority here. Different from yesterday, actually, there's not a separate opinion among the majority justices. So they clearly seem to be all aligned, not only on the reasoning like they were yesterday, but also without need for further explanation. And I think that's because in the framing of the opinion at the beginning, the justices are trying to explain and give a sense of the scope here. That Ms. Smith came in and said that she was willing to work work, obviously, with all clients, regardless of background, and would not discriminate on the basis of protected characteristics. But in this case, the court was conceiving of this as a pure speech case. They use that phrase in the opinion. They see this law in Colorado as one that would have operated to force Ms. Smith to produce messages with which she disagreed as a religious matter. And so I think that was clearly important to the justices here. And just like in the past that the court has decided that school districts cannot, for example, compel people to pledge to the flag or salute the flag, here Colorado cannot force someone to put a message on a cake that is squarely in disagreement with their religious beliefs.
Okay, former law clerk to two of the justices who were involved in today's decision. Jennifer Mascott, stand by there. I want to turn now to former federal prosecutor and NBC legal analyst Carol Lamb. I mean, as always, when you have a Supreme Court decision, it immediately, as you digest it, you say, well, what's next? Where's the next line? How far does this go? And of course, we'll be grappling with that for many years to come.
We will indeed, and this is going to be fodder for lots of lawyers and lots of trials in the future. I think it's very important to note that the majority opinion makes quite an effort to say this is really limited to this case and the facts of this case, and it then goes on to sort of criticize the dissents for what they say are sort of flights of imagination, all these hypotheticals, and they say those cases are not this case. You know, don't talk about providing chairs, don't talk about not providing services to people that we're not talking about here. You know, the law. The way jurisprudence goes in the courts is you are only supposed to decide the case in front of you at that moment and not decide other cases. As Danny has pointed out, there does appear that there will be a slippery slope here. There will be a lot more legal challenges to other providers of services in the future who say, you know, this is a work of art, this is my speech. The way I tie the bows on the chairs for a wedding is, for example, a form of expression, a form of my speech. The majority opinion here says, don't go there. That's not what we're deciding today.
Carol, thank you so much. I want to turn to Laura. Jared, you know, to pick up, Laura, on what we were talking about before, I'm looking at Justice Sotomayor's dissent, and in some ways, and I think you used this word, this case is the sequel to the case 5 years ago regarding the Colorado baker. And Sonia Sotomayor actually refers to that at the very beginning of her dissent, and she says that what a difference 5 years has made. And when you look back and you think about what has happened in the 5 years since that decision and this one, which is so different, it's that you have three new justices on the court. It's pretty clear what she's saying there.
Yeah, the makeup of the court is so different, and the tone that these justices have used in today's decision and yesterday's on affirmative action, I think is striking. These are justices that clearly are so far apart and really sharply divided on these important social issues of the day. Normally, you know, that might happen behind the scenes. It's playing out in public, in writing, in these decisions in really powerful ways. And the Justice Sotomayor is making sort of a large argument, a sort of the parade of horribles that she lays out that will flow from today's decision. But it's interesting, Justice Gorsuch is very honed in on the idea that the state of Colorado stipulated, which means it agreed to a number of things, and I think that might have tipped the scales in this case. He writes here, Savannah, the parties have stipulated that Ms. Smith seeks to engage in expressive activity. It's pure speech. And I think that that's a really powerful thing, because if the state hadn't stipulated to that, if it hadn't stipulated to the idea that she's making customized art, if it hadn't stipulated to the idea that she's a public accommodation, remember, she's not a restaurant. She's not holding herself out to the public in that type of way. Certainly, she's offering her services to everybody. But if the state hadn't made those stipulations, I think this might have been a different case.
It brings me back to law school, Laura, where sometimes it's how you fashion the question. And by defining this, and Colorado acceding to the fact that this is a case about free speech, in some ways that ended up being decisive to the outcome here. Let's go to Kelly Robinson, president of the Human Rights Campaign. And again, reading from Sonia Sotomayor's dissent, she says, the opinion of the court is quite literally a notice that reads, some services may be denied to same-sex couples. The majority vehemently denies that this decision stands for that.
This is a dangerous decision. And what it does say is that places of public accommodation can turn away a good or service for custom work. What that means is that gay couples can be denied custom wedding cakes, custom websites. That's a dangerous precedent to set. What I also want to say is that it does not undermine other non-discrimination protections that have been guaranteed by Bostock. And I think it's really important for us to make that clarification so that when people are going about their day, when they're going into different public spaces today, when they're applying for employment at different places, they know which rights are protected and which have been compromised based on this decision.
All right, thank you so much. I want to go to Kelly O'Donnell, who continues to watch. And once again, reminding folks we await another decision having to do with student loan debt forgiveness. But Kelly O'Donnell, you've been reading through the majority opinion and the dissents.
Yes, and I think you reminded our viewers that Justice Sotomayor is reading her dissent in court, and that's part of why there is a delay in hearing the outcome of that second case. But part of what she talks about here is that public accommodation laws are also intended not to just bring about equal treatment for all different kinds of categories of Americans. She cites those with disabilities, for example, but also to ensure equal dignity so that people who might be in that group, and part of what she talks about is those who are disabled and how sports arenas, for example, have had to provide accommodation so that if you are in a wheelchair, you have access to that. And part of that is the dignity that comes with being able to participate without feeling discrimination in a public setting. And she talks about how the First Amendment is not intended to give a business the opportunity to opt out of serving those who are otherwise protected against discrimination. And so her dissent, much like we saw with the case yesterday with affirmative action, which speaks about larger implications in American life and what this can mean, will certainly be something that people who are concerned about this opinion will want to read and explore a bit more. The court, she says, reaches the wrong answer in this case because it asks the wrong questions. That's part of what she is trying to get at here, that this company has never provided a wedding website and has never had its actions tested under Colorado's law. That's part of what she explores here. So she is arguing that this is looking for a case to have the opportunity to publicly announce that because of her religious views and the use of her free speech and creative artistry in a website, that she would publicly announce that she is against gay marriage and to be able to support, as she says God is calling her to do, traditional marriage. The justice also writes in here how that kind of an environment can lead to other concerns, where she even raises the specter of a social system of discrimination created an environment in which LGBT people were unsafe. And she invokes the name of Matthew Shepard. She says, who can forget the brutal murder of Matthew Shepard, who was targeted by two men, tortured and murdered? So she's trying to make that case that if people are not treated equally at a place of business, that there are other ramifications that come from that in the absence of being treated equally and the dignity that she argues is intended in the law about public accommodation. Samara?
All right, Kelly, thank you. Continue listening if you could. Senior legal correspondent Laura Jarrett is with me now. And actually, as we have this moment, I mean, we have Justice Sotomayor reading parts of her dissent from the bench, and it's worth kind of opening the curtain up a little bit because, you know, you have been there on decision days, as have I. It used to be not all that common that justices would read portions of their opinion or read their dissents. It's become more and more common in recent years. And it does speak to something I think you raised earlier, which is the tension that appears between the lines and sometimes, you know, overtly on this court. And it sure seems like that's what's happening at this hour as Justice Sotomayor is reading parts of an impassioned dissent.
Yesterday, she went on for the better part of 20 minutes on the affirmative action cases, and she has obviously read dissents before when she's been passionate about issues, and this one is clearly no exception. But it is worth noting that they're doing something in these opinions when they're talking to each other that is different in kind. The barbs that were traded between Justice Thomas and Justice Jackson, the newest justice on the court yesterday, in footnotes, no less, were quite remarkable. And I don't mean for it to be inside baseball, but I think it does show that even on the court, with these justices, these 9 justices with lifetime appointment, these social issues of the day, which are debated hotly elsewhere, are debated amongst those justices on the court as well. So we will await to see the student loan decision on the president's student loan forgiveness program. That's the next decision that we are waiting for, the final one of this term, which again could likely prompt a lot of strong feelings. People have very strong feelings. Borrowers, more than 40 million Americans, hold some student loan debt. So it's a program that is wide in scope, and we'll see whether, in fact, the court allows it to go through. It's one of those decisions, Savannah, that could come down in any number of ways. The court could decide to let the program go through because the people that sued, that states that sued, they could decide that they don't have standing. So even if these justices don't agree with the president's plan to forgive all that debt, if the states don't have standing, then the program would be allowed. Or the court could decide, you know what, the president didn't have the authority to this. This is a lot of money. This is something with a lot of economic and political significance, and so we're going to strike it down. And so we await to see what the court does as soon as Justice Sotomayor wraps up there on the bench.
Yeah, and just to pick up on the point from earlier, she writes in her dissent, when the civil rights and women's rights movements sought equality in public life, some public establishments refused. Some even claimed, based on sincere religious beliefs, constitutional rights to discriminate. The brave justices who once sat on this court decisively rejected those claims. So again, when you're talking about tone, and it is true that it sometimes is the battle of the footnotes, and that's how we can see where the divisions are among the court when you see a big landmark case such as this one. Going back, Laura, to this student debt relief case that we wait right now. You just touched on it, but just so folks who are tuning in can understand, you know, there's a hurdle to before you sue on something and you say, I don't agree with this program. I don't, you know, it's not constitutional for this reason or that reason. The first hurdle is, do you have any business being in court at all? That's the issue of standing that you so often hear about. And here in the debt relief cases, both of them present real issues of whether or not these plaintiffs are properly before the court at all. And if the court decides they aren't, then the case goes ahead whether or not, the program goes ahead whether or not the justices like it or not.
That's right. And there are different groups here. Remember, we have 2 borrowers that sued who actually wished that they had gotten covered under the program. And then we have 6 red states that do not want the program and have sued on slightly different grounds, but is trying to say that allowing the program would go forward would hurt their coffers. And so, again, we'll see how it breaks down. It could be the case that they don't think that the borrowers have standing, but they do think the states have standing. But as long as you have one, that's all you need to have standing. And then once you get into court and you can prove I've actually been harmed, then the issue is going to the merits. And on that one, the Secretary of Education invoked a post 9/11 law called the HEROES Act. And under that, it says the Secretary of Education can make changes to the student loan program. And the issue there is whether it was specific enough. Did it give the Secretary of Education a specific enough authority to go through with this program? Or does the court think, you know what, this is so big, this is so vast and so important, you really needed explicit congressional authorization to do something like that? And so that's what we're going to be looking for to see exactly how the case breaks down there.
Absolutely, and we await that decision, which would be the final decision of the term. Our legal analyst, Danny Savalos, joins us now as well. And as you take a step back and you look at how this court has changed, the ideological makeup of the court, you go a year ago, we had the Dobbs decision overturning Roe v. Wade. We have yesterday's decision on affirmative action that, while not overruling past precedents, comes very, very close in terms of severely limiting how race can be used at all in terms of admissions processes by colleges and universities. What are your thoughts as you think about where the court is right now in American life?
Certainly one thing that has happened with the court is that it's become unbelievably predictable, which I think is an unfortunate byproduct of the divide between the conservative and the liberal justices. One would hope that each justice would look at each case with their own fresh, neutral eyes. But certainly there are criticisms to be leveled against the court that it has become ideological. And because the majority happens to be of one particular bloc, now we're seeing a lot of decisions that that tend to go that way. However, we still have some cases that we're waiting on where we might see, I rather think, on the standing issue you just discussed with Laura Jarrett, that there is a possibility that the court might find in favor of the Biden administration on this standing issue and may conclude that the states did not have standing to bring this case for a very specific reason. The court and federal courts in general, this is not a typical standing case. This is a standing case where it seems like one of the parties engaged in a strategic move to leave out the party that did have standing, Mohila, and bring it on behalf of the states who arguably did not have standing. Look for the justices to possibly surprise us here, and possibly you may see a ruling for the Biden administration by this conservative majority on the issue of standing, which technically doesn't reach the merits.
Yeah, that's the Missouri Higher Education Loans, the loan servicer in one of the states that sued. But as you're pointing out, it's the states that sued and not the loan servicer. And so it gets kind of technical there, but that's one of the issues of standing that the court will grapple with. On the larger issues, I want to go back to Kelly O'Donnell at the White House, because, you know, you can't talk about this in a vacuum. It obviously happens in a political context. We saw that Democrats felt that their fortunes at the ballot box were quite enhanced by the Dobbs decision. And now we have the affirmative action decision, but public views on affirmative action are quite different. How is the White House handling some of these decisions, and what is the strategy there?
Well, certainly all of these things have political implications for the Biden White House as we are looking at a campaign year, and believing in policies is one part of what the administration stands for, but then they have to put it in the calculus of how is this playing politically. And when we look at things like the student loan case and what the outcome will be today, the administration has said they believe they are on the right side of the law. We'll see what happens here. But we also can look at the fact that the president's approval rating among younger voters went up after he embraced this policy and argued that there was a real need for student loan relief to try to help young people who have been burdened by this weight of debt and all the complications that come with it, of the original amount that one borrows to pursue their education and how over time that balloons, and how, given the pandemic and all of the other economic concerns of inflation, that is really an oppressive thing for many Americans. And so he wanted to provide this relief, $10,000 under certain circumstances, $20,000 when people meet qualifications, including Pell Grants, and it includes 43 million Americans. Well, those who might benefit from that are certainly tuned into this policy and the outcome today. And so we saw among younger voters, who can be very important for a Democratic candidate in particular, the president's approval has gone up. So that's something he wants to try to maintain. We know younger voters are among those who are often the least likely to stay, or the most likely to stay home, not engaging on voting day, even though they might be very politically active. So that's part of it. They're already looking at ways to try to deal with the repayment that is scheduled to resume. We'll see what happens again with the outcome here. But a lot of that is tied politically to the president, including the policies as well.
Kelly, let me just jump in here, because we actually just received this decision we're waiting for on student loans, the Department of Education versus Brown. This is the case I'm reading. That's the one that has to do with the individual borrowers who sued. And this is a quick read just of the holding, so we will continue to digest it in terms of the reasoning. But it says that the respondents, the people who sued here, have not established any injury that they suffered is actually traceable to the plan. They lack standing. So now we've had this whole discussion, and now if you're at home, you understand what this means. They're saying the court has no jurisdiction to address their claim. If that holds, this is for one of the cases that I'm looking at right now, if that holds, that would mean the student loan forgiveness program could go forward. But again, we continue to digest it, and it's a pair of cases. So the one case was a set of states that had sued to stop this student loan forgiveness plan from going forward. The companion case were two individual borrowers who either received no debt forgiveness or not as much as they had hoped to get, and they sued. And in that case, that's the one I just read, where the court has held that it is they do not have standing. They do not belong in court. They are not properly before the court, and therefore the court will not weigh in on the merits of that claim, which, as I turn to Laura Jarrett, in this particular case would mean that the student loan forgiveness plan goes forward.
So it's interesting that they did this one first, Savannah, because this is the easier case. These are two borrowers who didn't get relief under the president's proposed plan, but want relief. One of them doesn't hold federal student loans at all. She has privately held loans, so that's why she doesn't come under the plan. The other one wanted to get a bump for having to get a little bit more money, because under the plan, you can get up to 10 grand if you reach a certain income threshold, and then you can get an additional 10 grand if you went to school on a Pell Grant. Taylor didn't go to school on a Pell Grant, and so he didn't get that additional bump, and that's why he sued. But understand, under both of these issues, under both of these arguments, these are people who actually wanted to get their loans forgiven. And so what the court is dismissing them for not having standing is because if they got their way, nobody would get any forgiveness, right? If the actual injunction that has blocked this plan was actually to stay into place, since nobody would be covered, that's why they're dismissing it, because you have to be able to have the harm that you're saying in court. You have to be able to have it redressed in some way. And so if nobody would get any coverage, then obviously that would defeat the whole purpose, since they want to get covered. So that's why it's interesting that they did this one first.
Well, we have the second case now, Laura. Okay. I'm actually going to let you step out here and read it really quickly. I will say that first case was a unanimous decision by the court. It does say that Missouri, the state of Missouri, does have standing to challenge the program here, and we'll continue to read it here for a second. Let me turn to Danny Savallo. So on that first case, I think Laura explained it pretty well. That was the easier case to dismiss. Now we got to read the second case, which is the set of states that are suing to stop this debt relief program. We have to see if they have standing, and if they do have standing, whether or not the court finds that the Biden administration had the authority to have this debt relief program.
And it appears those two questions are answered. And the state of Missouri, the court appears to have concluded, does have standing, even though the argument was made at oral argument that the real harm was through Mohila, that student loan servicer. The court has decided that the state of Missouri does have standing, but it appears to have also decided on the second issue whether the text of the HEROES Act authorizes the Secretary's loan forgiveness program, and it appears to conclude that the text of the act, the federal law, does not authorize the loan forgiveness program. In other words, this came down to really two words, to modify or, the power of the Secretary to modify does not permit the basic and fundamental changes to the scheme designed by Congress. So, in other words, when the Biden administration attempted to modify, as it was given power to, it did not have the power to do what it sought to do. In essence, this was too much. This was more than a modification.
I want to turn to Laura, if you're ready to talk to me about this, Laura, because it certainly, in reading it, seems like the court may be striking down the student debt relief program with regard to this case that the states brought. I'm just reading it myself, but it says this all leads the court to conclude that a mass debt cancellation program is one that Congress would likely have intended to do itself, and in such circumstances, the court has required the agencies to point to clear congressional authorization. This goes to the issue of, look, if you're going to do something huge like this, the court says it's Congress under our Constitution that's supposed to do it, not some federal agency. And that seems to be what the case hinges on here.
The upshot is that this plan is not moving forward for the Biden administration. All it takes is one person, one entity, one state to have standing, which in this case, it's decided that it does. And so then it reached the merits. And on the merits, you're right, Savannah, the court is saying they did not have clear congressional authorization for this. They looked at the statute and they said, it's not going to work for you here. Now, that doesn't mean, we should be clear, that the Biden administration couldn't go through a different regulatory process. It had always had that option, but it didn't take that route. Instead, it went through a different process in order to make this plan go through faster. And I think it's worth noting that that this is not to say that you can't have your student loans forgiven forever. If the Biden administration decided to go through that much more arduous process, it could do so. But that does seem unlikely at this point. And we should also mention that this plan was about a one-time forgiveness, a lump sum to lop off your bill. It's not about the payments that have been on pause largely since the beginning of the pandemic. In March of 2020, remember, under the Trump administration, all federal loan payments were put on pause. And the idea there was to give some people a little bit of breathing room during COVID to help make sure that you weren't in an economically tough position. Those payments, regardless of what had happened here today, are set to resume this fall. And so it was really two pieces here. The plan that the court was evaluating had to do with lump sum payments that were going to be lopped off of the bill. But the general repayments for many people who may not have gotten enough relief under the president's plan, those are set to resume this fall. And again, the headline here is that the president's student loan forgiveness plan, the larger plan, which affected more than 40 million borrowers, will not go forward.
And it seems the court is saying they just went too far in interpreting this same statute, by the way, that under the pandemic had the Trump administration pausing loan repayment. The Biden administration then continued that pause. And then last summer, August of 2022, the Biden administration had attempted to use that same legal authority that says you can pause in a time of emergency to say, you know what, for that same reason, we're just going to cancel it and forgive this piece of debt altogether. That is where the court said that was a bridge too far. So let me turn to Kelly O'Donnell, because essentially what this court is saying is, if you want to do this, that's fine, but you need to go to Congress. You can't try to do an end run and do it some backdoor way and override the power of Congress. The Constitution requires that Congress weigh in on a matter of such significance.
In some ways, Savannah, the court is concluding its term with a very clear message about executive authority. And this conservative court is not comfortable with a movement of executive authority, as you're describing, needing Congress to take these actions. In part of the opinion, it says to waive or modify does not mean completely rewrite, and that the precedent needs to be respected in that way. So the White House is commenting on this. As we talked about, there's a lot of political implications for President Biden, for Democrats and the administration here. And so what we've just learned from White House officials is, while we strongly disagree with the court, we prepared for this scenario, and the president will have more to say today. He has not had anything on his public schedule, so that's an indication that the president will be making comments. We saw him do that yesterday as well. The president will make clear that he's not done fighting yet. We saw that as well with affirmative action yesterday, and he will announce some actions to protect student loan borrowers. So this is a policy area where the White House is able to, again, try to scrub the regulations, to look for ways where they can take action that does not require Congress. That may, again, be subject to the courts down the line. And he'll be making it crystal clear to borrowers and their families that Republicans are responsible for denying them the relief that President Biden has been fighting to get them. That is a reference, of course, to they could have gone to Congress if they believed that that would have resulted in new legislation to provide this kind of student loan relief. And so when you look at what the court is saying, executive power has its limits. That's to be expected with a conservative supermajority court like this. The White House had said they believed it was within the law. The court views it differently. And so now this will have, again, sweeping ramifications for Americans who hold this kind of debt. The political discussion will certainly ramp up because of this. There are those on the conservative side who have felt all along that this action was unfair to those who never sought higher education, but as taxpayers would be shouldering the cost of this, or those who did get loans and paid them back as required by that loan contract. So there are strong feelings around this, and certainly the president and his team, we expect he's been being briefed as these opinions have been coming down. They've had time, certainly, to analyze what they thought the different options for the court would be. Certainly, now we will see what the president has to say and what steps come next after this very significant ruling.
Well, and to be clear, this affects up to 43 million borrowers. However, none of them have ever yet seen this debt relief, because almost as soon as announced, it was challenged in court and put on hold. If it had gone through, it would have been up to $400 billion in cost to give this debt relief. Let's turn right to Brian Chung, our business reporter. And Brian, this will have a huge economic consequence. Student loan debt is a pervasive issue, a pervasive problem. But it seems today the court has made clear that they feel it's a problem for Congress to deal with.
Yeah, and as you mentioned, Savannah, I mean, this was a program that some applicants had already filed with the Department of Education to ask for that forgiveness before it was shut down because of the court proceedings. And when we talk about the numbers here, you mentioned, yes, 43 million borrowers could have been impacted by this, but ultimately there could have been about full cancellation for about 20 million of them. Now, interestingly, when the Department of Education opened up the portal in the fall last year, they took 23 million applications. 16 million Americans were already approved as of a tally earlier this year. Now, for what it's worth, at the kind of micro level for individual households, this could have been savings of a few $100s per month, depending on the type of degree and the type of debt that you were taking out. But for what it's worth, again, this would be so impactful for a lot of those Americans that maybe had been excited about the prospect of having that extra money as a cushion, which could have been very impactful for a lot of specifically low income, in many cases also minority families. Now, the open question here is what happens with payments going forward. There was the freeze on payments since March 2020 as a result of the pandemic. And what's interesting is that as a result of the debt limit agreement from earlier this year, the Biden administration is not allowed to further extend the pause on student loan payments, but there has been interest from the administration, knowing the risk of the outcome of this Supreme Court case, about trying to transition payments back once they restart later on this fall. So what could this look like? We'll have to wait for the Department of Education to weigh in. But one possible solution here could be, for example, restarting the interest payments as is required come September, but at the same time allowing for a grace period by which any sort of missed payments would not have an impact on your credit score. That could be one way that the administration would transition this, but the big takeaway for Americans that are trying to figure out, what does this Supreme Court case outcome mean for me? It means that some payments in some form will resume later on this fall, Savannah.
All right, Brian, thank you. Stand by there. Let me turn back to Kelly O'Donnell, because this, of course, has always had a political context to it, especially as August 2022 is when this debt forgiveness was announced, and was the Biden administration, of course, accused of giving a freebie to young voters right before a crucial midterm election.
So much of that has played out as being very potent in the political sphere. Young people who saw this as an opportunity to have a little more control over their finances have been motivated by this. As I mentioned earlier, the president's polling numbers among younger voters have gone up after this decision this policy was first embraced by the Biden administration. And we see that some of his more favorable ratings are among that under 35 age group. And on the other side, there has been a fierce sense of anger and frustration from those on the conservative side, those who did not attend college or went a trade school route or were not qualified for this kind of relief for whatever reasons, about that tax burden you mentioned, the $400 billion potential cost, which would be shared by all Americans. And the administration has argued that there is value to the broader society to reduce some of that weight of debt on those borrowers, because then they have money available to spend in businesses, to use to buy a home, all of the things that are the engine of our economy. That's a fertile ground for debate. And certainly the administration will look for other ways. One thing, for example, is we know there's already some plan in the works for a grace period for repayment when those student loan payments are set to resume after that long COVID break. So people who've been under these rules had not had to make those monthly payments for a considerable amount of time now. And so even that adjustment alone will certainly have financial implications for those borrowers if they've had the benefit of that money they might have put aside for student loans being available to them month by month. This will be a big change. And so part of what we will be looking to see from the White House today are what plans or programs can they offer to give either some more time or a grace period or those kinds of things. Yeah. So there's a political argument to make. There's a practical one in implementing this. And then there is the court saying go back to this case. Is there a new way to approach this from Congress? That seems quite unlikely in the current makeup, with Kevin McCarthy as Speaker and with not having the kind of margin in the Senate that the administration would need to try and put this forward in the traditional way the court is saying, through legislation.
Well, and Kelly, you bring me right to the point. I want to wrap up our time with Laura Jarrett on this very issue, because, I mean, if you take a step back and you look at what's been happening, you know, administrations prior to this, going back decades now, many administrations have sought to use executive power to do things that they cannot do via Congress because of this paralysis that we see in Congress. And time again, you see the court saying, look, you can't go the easy way. You can't go that backdoor way, not when it regards something as significant as this. But I think it really underscores the tension there, that when you have Congress essentially not functioning on some of these major issues of the day, administrations of every political party have tried to use other means to get their agendas through, and the court has consistently said, not so fast.
This is the court saying there are no legal shortcuts. As much as you would want this type of program to go through, you have to go about it the right way. And it's worth noting here, the court is very much cued in. Justice Alito here very much cued in on something you and I discussed before, Savannah, which is sort of the perceptions of the relationships on the court. And at the very end of the opinion, I want to just point out, he writes, reasonable minds may disagree with our analysis. In fact, at least 3 do, meaning his other more liberal colleagues. We do not mistake this plainly heartfelt disagreement for disparagement. It's important that the public not be misled either. Any such misperception would be harmful to this institution and our country. And so it just strikes me, when we have 2 major decisions and such social issues, this is how the court has wrapped up its term, Savannah.
A deeply fractured court, but interesting that Justice Alito is trying to say, don't worry, all's fine. This is just what reasonable minds do. They disagree, but they do so respectfully. Laura Jarrett, thank you as always. Much more on NBC News Now, also tonight on Nightly News. Most of you return now to Today. I'm Savannah Guthrie. This has been an NBC News Special Report.